So I want to first give everyone a background of the United States Supreme Court. We asked you how many cases were decided in the most recent term. There were 67 merit decisions, 58 oral arguments. One of our panelists this evening took part in one of those. 2 shadow docket rulings, which shadow docket refers essentially to an unsigned decision that grants emergency relief. And then 8 summary reversals. The newest judge, you'll see here, that's Amy Coney Barrett. Several of you got that correct. And in this last term, like during the pandemic, instead of having oral arguments in person, they did it over the telephone. And normally when they do it in person, the judges ask questions, sort of like it's a free-for-all, but they did it in a more orderly method on the telephone, which is by seniority. They will return to in-person oral arguments in the next term. So here are opinions authored by each justice. You can see that Justice Thomas had the most. He has always been the one for several years who has the most decisions issued, also the longest decisions issued as well. And Sotomayor is second. Here are the opinions that you can see since 2005. You can see this is the year of the pandemic, where we had the fewest cases or decisions issued since the Civil War. So you can see the pandemic certainly had an impact on the number of decisions that were issued by the Supreme Court. And even in this last year, it was just slightly higher in terms of the number of decisions. So justices, you may have heard that they're in the news that they're conservative and liberal justices. To the extent that these parties sometimes tend to agree, if like the liberal ones may agree, conservatives, you can see it's not an exact pattern at all. The parties that agree the most, you have Roberts and Kavanaugh. Kavanaugh was actually in the majority the most of the time. He was 97% in the majority of cases issued by the Supreme Court. After Roberts and Kavanaugh, you had what are considered liberal justice, Kagan and Sotomayor, and then the 2 justices with the most disagreement, you might say, were Alito and Sotomayor. So Alito is known as a conservative justice, and Sotomayor is. Some key stats from this last term: 43% of cases were unanimous. We hear a lot about split decisions and a division in the court, but there are quite a few cases that are unanimous. The number of unanimous cases was higher this year than the last 3 years, though it's slightly lower than the 10-year trend, which was 46%. 21% of cases were 8-1 and 7-2, so you don't see that 5-4 split. This last year, only 12% were 5-4. So just want to provide you with some overall background before we get to our cases. Our first speaker this evening is Matt Ressing. He is a senior lecturer in legal studies at UGA's Terry College of Business. Professor Ressing previously taught business law here at Georgia College and started the very first Constitution Week Supreme Court review on this campus. Before his teaching career, he worked in the Washington, D.C. office of Arnold & Porter, and he now runs his own law firm in Milledgeville, where he represents local business owners and serves on the board of the Chamber of Commerce. An avid Supreme Court watcher, Professor Ressing has discussed his decisions on Georgia Public Broadcasting, Macon's Law Call, and Georgia College's WRGC. Professor Ressing holds a BA in English from Williams College and a JD from the College of William and Mary, where he was articles editor for the Bill of Rights Journal. He will discuss our first case of the evening, a case addressing first speech, Mahoning Area School District versus BL. And as he comes up here, I'm going to pull up his presentation.
Good evening, everybody. I'm going to be talking about the case Mahanoy Area School District versus BL. And you may not remember the name of the case, but you probably heard about it. This was the case of the cursing cheerleader. And I always play a little music before every one of my classes. If you've been in one of my classes, you know I call them law tunes. So your law tune for tonight is I Swear by All for One. There's a little icon on the corner of the screen. Gotcha. Okay.
Sorry.
All right. So this is the case of the cheerleader, a high school cheerleader in Middle Pennsylvania, who dropped an F-bomb so big it was heard by the U.S. Supreme Court. And the U.S. Supreme Court heard this case. Why did she drop this prodigious profanity? You know, where did this all come from? Well, BL was having a very bad week. First, she tried out for softball, didn't get the position she wanted. Next, she tried out for the school's cheerleading squad, and she wanted varsity, she got JV. So as the majority opinion in this case would say, as Justice Breyer would say, in his opinion, BL did not take the coach's opinions very well. This is what she ended up posting on Snapchat. A picture of her and her friend giving the finger, and you know, we can't quite see what she wrote there. It's been tastefully bleeped out, but we know what she said, right? In fact, let's all say it together on 3. Okay, 1, 2. But hang on 1 second, because I don't want you guys to get in trouble. We're here in school, and BL actually did get in trouble. She was kicked off of every cheerleading team. Didn't get on JV either. So before we start cursing in the auditorium, we might want to check our legal precedent. Let's check with our lawyers and see if we're safe. Yeah, is there any way we can drop that down? Perfect. Again, so what's the legal precedent? What cases is the Supreme Court going to look at in deciding the case of the person cheerleader? Well, they're going to start with this case in Tinker versus Des Moines School District. This is a very important First Amendment case. Back in 1969, really 1965, a small group of high school students wore black armbands to school to protest the Vietnam War, and in their mind commemorate the soldiers that died in that conflict. They were threatened by the school principal. He said, take off the banners, take off the armbands, or you'll be suspended. They refused to do it, and they got suspended. They got the help of the ACLU, the American Civil Liberties Union. They have one of their fine attorneys here tonight. And they took their case all the way to the Supreme Court, and they won. The Supreme Court found that their speech at school was protected. Okay. But even though this was a 7-2 decision, there were conflicting opinions on the court. We have a majority opinion by Abe Fortas. This is actually the guy who founded the law firm that I work for in Washington, D.C. And when he's on the Supreme Court, he makes this famous statement: students do not shed their constitutional rights at the schoolhouse gate. But we have a few other justices, like Potter Stewart, who, even though they agree with the outcome, they say children shouldn't get full First Amendment rights. And then we have John Marshall Harlan, who is one of the 2 dissenters in this Tinker case. He said, I would have sided with the school officials. We need to give them broad discretion to handle disciplinary issues. All right. Then we have Bong Hits for Jesus comes along. What happened here? This was a group of Alaska high school students who were waiting outside their school for the Olympic torch to come through on the way to the Salt Lake City Olympics. And just as the torch goes by, the cameras are clicking. One student unfurls this 14-foot banner, Bong Hits for Jesus, promptly gets suspended from school. And he brings it to court. He sues. He takes it all the way to the Supreme Court, but he loses. He loses his case. Now, why would he lose his case when the Tinkers will win their case? Well, they're off campus too, although still under the supervision of the school, part of a school-sponsored activity. Well, the Supreme Court really had some trouble with this. Normally, you're not allowed to regulate the content of speech. So you can say no signs, but if you allow a sign, it shouldn't matter whether it says Go USA or Bong Hits for Jesus. So content-specific restrictions are very suspicious. But here the court allowed it to happen. And what they said is, well, it's about drugs. And schools have a real interest in promoting an anti-drug message, so they had a right to shut this down. And in fact, in this opinion, they repeatedly say, don't read too much into this. It's just about drugs. But obviously it begs the question, if that banner had said something else that people found offensive and embarrassing to the school, but not drugs, do you think they would have found themselves in the same situation? And that brings up an even more recent case called Bell versus Itawamba School Board. And this was in the Fifth Circuit. Never got up to the Supreme Court. But important case nonetheless. A high school student, Taylor Bell, aspiring rapper, And he hears from a few female friends of his at school that there's these two male coaches that have been sexually harassing him. So he writes a rap about it. And he does this off campus, he records it off campus, and he posts it on his YouTube. Doesn't come to school with it, doesn't confront the coaches with it, but in this rap, it's in the gangster rap style, and he threatens the coaches, or at least he suggests that he might commit violence against them. This is a student who never had any disciplinary record, and there was no indication that he brought this to the school. But the coaches hear about it, they complain to the school, and the student gets suspended, effectively has to transfer for the rest of the senior year. Takes it to the Fifth Circuit, loses. They say, this doesn't count as freedom of speech. Even though you're off campus, the school had the right to punish you. Whenever you lose at an appellate level, you can appeal to the Supreme Court. They don't have to take your case. You have to ask permission. We call it petition for writ of certiorari. And that's what he did. He asked the Supreme Court to hear his case. And in fact, he brought some high-powered friends along. You can file what's called an amicus brief, where people say, Supreme Court, we think also you should really hear this case. And Atlanta rappers, Killer Mike, Big Boy, T.I., they all filed this amicus brief, along with about 50 other hip-hop artists. However, the Supreme Court was unconvinced. They did not take the case, and we'll never know what they would have thought about it. Okay, so where are we at this point? Are we ready to swear in the auditorium? These cases are all over the map. And in fact, that's what the dissent complains about. The dissent says, we're not doing anybody any favors by deciding all these cases based on sympathies. We should just have one set rule. So is there a method to the madness here, I guess is my question. Well, to the extent there is a method to the madness, it is this phrase, in loco parentis. And loco is from the Latin, not the Spanish, but I couldn't resist the Zoolander clip here. So loco parentis means you're in the place of the parents. And therefore, people in a school, teachers, when you're in their custody, can do whatever your parents can do in the way of discipline. Now, the dissent in this case would have said, this is almost a complete power, because they wanted to look at this in the context of 1868, when the 14th Amendment first applied freedom of speech to the states, and said, if we're going to take an originalist perspective, schools can stifle whatever they could stifle back in 1868. And that, as you might imagine, is a lot. But the majority was not willing to go so loco with the loco. They said, we are going to keep it pretty vague here. And in fact, they didn't really say what the school could do. They said that BL speech was far enough off campus it was okay. But the school might be able to punish a specific threat to school or students, a targeted bullying or harassment, not just a general FU, cheating or tampering with school security systems while off campus, which makes some sense. But the result of this approach is that every case is now going to have to come to the Supreme Court for resolution. It's going to be highly fact-dependent. They're not establishing a blanket rule. Anyway, what was the end result? What was the verdict? What was the vote? How many of these Supreme Court justices were friendly to BL SNAP? 8-1. Thank you, Georgia College.
Thank you so much. Our next speaker is online, and so I believe he's going to probably put on his video in just a moment as I introduce him. Jeffrey Kessler is co-executive chair of the international law firm of Winston & Strawn. He's one of the most prominent lawyers in the country, regularly engaged in high-profile sports litigation. He has litigated some of the most famous sports antitrust cases in history, including McNeil versus the NFL, the landmark antitrust jury trial, which led to the establishment of free agency in the National Football League, and Brady versus NFL, which led to the end of the 2011 NFL lockout. Some of Mr. Kessler's clients in the sports law area have included the NFL Players Association, the National Basketball Players Association, the Arena Football League Players Association, the National Hockey League Players Association, and the Major League Baseball Players Association. Mr. Kessler negotiated the current free agency salary cap systems in the NFL and NBA, and successfully represented Latrell Sprewell, in his controversial suspension arbitration. He also represented pro bono Oscar Pistorius, that double amputee athlete, in his successful arbitration to obtain the right to compete against able-bodied athletes around the world, and is representing the women's national team in soccer in their landmark class action litigation for equal pay. Mr. Kessler received a JD from Columbia Law School in 1977, where he was a Kent Scholar and on the board of editors for the Columbia Law Review. He received a BA, summa cum laude, from Columbia University in 1975. Please welcome Jeffrey Kessler, who will discuss Alston versus NCAA, a case which he recently secured a unanimous 9-0 victory in the United States Supreme Court on behalf of Division I men's and women's basketball and FBS college football players. Welcome to Georgia College.
Thank you very much. The case I am discussing, Alston versus NCAA, is an antitrust case. It was brought by classes of college Division I men's and women basketball players and FBS football players, which is the highest level of college football, challenging the restrictions that the NCAA have on the schools compensating the athletes in any way beyond giving them room and board and a scholarship. The NCAA's justification for those restrictions was what they call the principle of amateurism. And specifically, their defense was that college football fans would lose all interest in college sports if the athletes were able to receive anything beyond a scholarship for their efforts. This case went through a 10-day trial in the Northern District of California in Oakland under what's called the rule of reason. And the rule of reason under the antitrust laws means that first you see if the plaintiff can prove that the restrictions are anti-competitive, they substantially restrain competition. If the plaintiffs meet that burden, then the defendant can try to prove that the restrictions are justified by some pro-competitive effect that offsets it. If the defendants can meet that burden, then the plaintiffs can still show that the restrictions were overly restrictive. They were more restrictive than were really necessary to achieve the pro-competitive benefit. And in the end, the court might do a balancing of all those factors together. In this trial, the judge applied the rule of reason in this bench trial. And she found first that the restrictions were clearly anti-competitive because they restrained each competing school from offering any more compensation to the athletes. It's sort of self-evident. Just imagine if Toyota and General Motors and Mercedes got together and said, we're going to agree to not pay our auto engineers more than $10 an hour, right? That restrains competition, right? There was no doubt there was a restraint on competition. So the trial was about what was the justification and was it more restrictive than necessary. The NCAA could not prove that it needed these restrictions in order to keep consumer demand for college football. Why is that? Or basketball. Those sports generated billions of dollars each year. What the record showed is that the total revenue generated by Division I basketball and football was more than the revenues in the NBA, in Major League Baseball, in the National Hockey League. It was only second to the National Football League in terms of revenues. The record also showed that this money was dispensed to everyone except the college athletes. So, for example, the strength and conditioning coaches at Alabama, there are two of them, earn more than $500,000 a year, which is more than the president of the University of Alabama earns. The coach, of course, earned over $10 million a year. The athletic director earned more than $2 million a year. And what the court found is that there was no evidence that college football fans would care, that even motivated the restrictions. What the testimony was, they had these restrictions, as most cartel members do, to save money. And there was no evidence that if you allowed additional compensation to the athletes, that an Alabama football fan would suddenly stop rooting for the Tide. So the court did find that there was some need to limit cash payments to athletes to keep it from just being indistinguishable from professional sports. So in her final decision, she ruled that the NCAA could no longer restrict all the benefits to athletes that promote education. These were things like scholarships, postgraduate scholarships, computers to study, tutoring, study abroad, internships, academic achievement awards, just like they give athletic achievement awards. All of that they couldn't restrict. But she let them continue to restrict pure cash compensation. And that's how the decision ended. It went up to the Ninth Circuit. And the NCAA's argument in the Ninth Circuit was that this whole decision should be thrown out because 37 years ago, the Supreme Court decided in a case called Board of Regents versus NCAA that amateurism was a special justification, that the NCAA should be given special deference that no other organizations are allowed under the rule of reason in order to try to justify their restrictions. So all their restrictions on compensation should be permitted. That was the argument. The Ninth Circuit rejected that argument, 3-0 in the Ninth Circuit. And the Ninth Circuit also rejected challenges that the rule of reason had not been properly applied. The NCAA then appealed for certiorari. Now they had to make a decision. It's quite interesting. They had at the district court preserved part of their restrictions, the ones against cash compensation. We had decided that we were not going to appeal to the Supreme Court. We were going to take all of these additional benefits for the class members that they so badly needed and live with the decision if cert was not granted. But the NCAA went ahead and they decided we're going to argue we're just entitled that all of our restrictions have to be kept in place because we have this 37-year-old victor from this Board of Regents case. Supreme Court granted cert. The Board of Regents issue became the centerpiece of the debate before the justices. And this is what the case was. Board of Regents was a case the NCAA lost under the antitrust laws. It was a case in which they had imposed restrictions on college broadcasting so that there couldn't be individual conference broadcast deals, there couldn't be individual schools deals, only the NCAA could control college broadcasting. The Supreme Court struck that down under the rule of reason. In fact, it found there was summarily an antitrust violation. But in dicta, it said, of course, the NCAA has to have some rules as a joint venture sports organization, such as preserving the principle of amateurism. And the NCAA said this meant that we are forever entitled to this special protection. And by the way, they had convinced other circuits to adopt this view, particularly the Seventh Circuit and possibly some other circuits. And they argued the Supreme Court should take the case to resolve this split. Well, they got exactly what they wished for. The Supreme Court resolved the split. And the way the Supreme Court resolved the split 9-0 is to say, NCAA, you are a multi-billion-dollar business of competitors that get together to exploit these athletes who work for you. You are subject to the antitrust laws like any other business in America. And whether or not Board of Regents dicta was correct 37 years ago, and it was just dicta, it is certainly not correct today, looking at the record of what these giant businesses have become and the evidence that was put together. And instead, all the justices joined in the idea that this was a cartel, in effect, getting together to restrict competition, where they were doing so in a manner that didn't seem to further any legitimate pro-competitive objective. So where did the NCAA end up? Well, they ended up far worse if they had never filed for cert in the first place, because now they can no longer argue in any circuit that Board of Regents gives them any protection. And the justices have made clear that had we challenged all the restrictions on appeal, remember I told you we decided not to further challenge the district court's decision before the Supreme Court to seek cert on where they sustain them, we very well may have struck down all the restrictions as well. In fact, there's a concurring opinion by Justice Kavanaugh who felt compelled to say that basically under the principles adopted by the Nine, he was very skeptical that any of the NCAA's restrictions could be justified. And one of the points here was that you don't need NCAA restrictions because each conference can have their own rules. If you're in the SEC, where you have each school making more than $200 million a year in their athletic programs, you might have different rules than the Patriot League has, where no one is making significant revenues off of the backs of those athletes in those sports. So the idea was to let competition flourish. Now, what's happened since then? Since then, the NCAA had to decide what to do on the issue of names, images, and likenesses, which is these are restrictions not on the NCAA paying money directly to schools, but allowing athletes to get sponsors, allowing athletes to make money on the internet and social media, allowing them to earn money in effect outside of school the way any other students on the campus can. If you're an actor, you can act. If you're an inventor, you can sell an invention. If you're an entrepreneur, you can do that. If you're a musician, you can do that. But athletes couldn't do any of this without losing their eligibility. After the 9-0 decision, the NCAA decided, I believe quite wisely, that the jig was up. So what they did is that they have suspended this year all of their restrictions on names, images, and likeness payments. And if you follow this all in the media, you know there's been an explosion of payments to these athletes. Some teams, every member of the team has gotten a sponsorship opportunity or a payment. This has affected all sports, not just football and basketball. It has brought money to gymnasts. It has brought money to volleyball players. It has brought money to rowers. And many of these athletes, this is life-changing to them because many of them come from backgrounds not of any means. Many of them don't graduate, especially on the Division I basketball, football, and basketball teams because the evidence showed they have to work 50 hours a week for their teams before they pick up a book or go to a single class in terms of that. So this is life-changing financial ability that they now have. And this is where the state of the law is right now. The NCAA is going to Congress. They're asking Congress, please give us an antitrust exemption so we can go back to restricting the athletes. I don't see that happening. That's where we stand today. The final point I will make is that when we went up on appeal, many people said, well, this is a conservative Supreme Court. Don't you think that you're going to lose this case? Won't they be pro-business? And I never viewed this as a liberal conservative case. It has turned out not to be a liberal conservative case. There is a uniform view of the justices, and it's interesting. On antitrust cases, the Supreme Court has only twice in the last 30 or so years ever agreed 9-0 in favor of an antitrust plaintiff. Once is for our case in Alston. The last time was in a case where the NFL was arguing, a case called American Needle versus NFL, where the NFL was arguing for it to be immune from the Sherman Act, the antitrust laws, for its restrictions. So one thing we sort of know right now, the Supreme Court of the United States does not believe that sports entities should get special treatment under the antitrust laws that every other American business does not have to face. So thank you very much. Those are my remarks on Alston.
Thank you, Mr. Kessler, and congratulations on your win, and congratulations to all the student athletes who you represented for that. Our next speaker is Rahul Garabadu, and he is the voting rights staff attorney at the ACLU in Georgia. As a native Georgian, Rahul is passionate about ensuring that elections in Georgia are free and fair. In his current role, Rahul litigates cases involving voting rights and provides his expertise regarding Georgia and federal election law. Rahul's involvement in democracy and voting rights spans the globe. Prior to working at the ACLU of Georgia, Rahul served on a delegation that traveled to the Democratic Republic of Congo on behalf of the Atlanta-based Carter Center to help set up a long-term election observation mission in advance of presidential elections in the country. In 2017, he traveled to Myanmar to provide research support to local lawyers and activists pursuing constitutional reforms in the country. While in law school, Rahul worked as a student attorney for Protest Democracy, a nonpartisan organization dedicated to protecting elections and preserving the rule of law in the United States. In 2011, Rahul interned at the White House Council of Economic Advisors. Rahul received his JD from Harvard Law School and his BA in Economics and Government from Georgetown. He will discuss voting rights cases before the Supreme Court, including Brnovich versus the Democratic National Committee. And as he comes up, I'll share your.
Well, good evening, everyone. My name is Rahul Garabadu. I'm the voting rights staff attorney at the ACLU of Georgia, and it is a real pleasure to be with you here tonight and to be among this very, very distinguished panel. I'm going to be here to discuss the Supreme Court case Brnovich versus DNC, Democratic National Committee. I did not argue this case. I did not litigate this case, but as a voting rights attorney, I will be living the effects of this case in the years and decades to come. So let's jump right into it. So this case dealt with two specific Arizona election laws that were at issue. The first was regarding out-of-precinct ballots not being counted, and the second was a ban on third-party ballot collection. Now, what does that mean? Let's talk about that first one, Arizona's out-of-precinct ballot policy. So in many states, including Georgia, if you want to vote in person on election day, you're assigned to a precinct that you have to go to vote. So if you wanted to vote on November 3rd, 2020, and you wanted to vote in person in Georgia, you would have to go to, say, the local middle school that you were assigned to vote in, right? That's called assigned precinct voting. And it's different from some other models of voting called vote center models, where you can go to any kind of precinct in your county as long as you're an eligible voter. So Arizona counties offer a mix of options when it comes to either assigned precinct voting or vote center model. But most counties operate on the assigned precinct model, the model that says that on November 3rd, you have to go to Cooper Middle School to vote. That's where you vote. And in the counties that use the precinct-based method of voting, if you go to the wrong precinct, you can't vote at all in Arizona. Well, you can vote, but if once they find out that you weren't assigned to that precinct, your vote doesn't count anymore. So even if you're in the right county, even if you're an eligible voter, your vote doesn't count. And that's a little bit harsher of a restriction than many other places in the country. In many other places, if you go to the wrong precinct, your vote will count for certain elections. So for example, your vote for the presidential election, if you're an eligible voter, that'll still count, right? Because it doesn't matter which precinct you live in. Everyone in the country is voting for president, vice president. And then, statewide elections, your vote will count because it doesn't matter where you are in the county or the state. You're still voting for the same U.S. senators. So Arizona's new law was a little bit less forgiving. If you were in the wrong precinct on election day, you were out of luck. The second law at issue in Brnovich was a ban on third-party ballot collection. So that just means that a third party couldn't drop off your sealed mail-in ballot for you, either in a mailbox or in a drop box to vote. There were some exceptions that were made for family members or caregivers of the person who was voting, but by and large, third parties could not submit your ballot on your behalf. And that was punishable as a criminal felony if you violated that. So the Democratic National Committee and several affiliates in the state of Arizona challenged both of these laws. They filed a lawsuit challenging these policies, arguing that even though these policies seem facially neutral, right, they're not facially discriminatory in any way. They're not saying, don't count the votes of Black voters. They argued that this had a disparate impact. It had a higher impact on voters of color in Arizona. Specifically for out-of-precinct provisions, the Democratic National Committee argued that with voters of color, it was more likely that their precincts would be moved at the last minute. So this out-of-precinct ballot provision would affect more voters of color because of that. And then when it came to when it came to the third-party ballot collection rules, they argued that, especially for Native Americans who often did not have home mail delivery, it was very difficult to get to a mailbox, a drop box, and so that this ban on third-party ballot collection would hit Native American voters much harder than the general electorate. So that's what they filed the lawsuit on. So they filed this lawsuit under Section 2 of the Voting Rights Act. And I gave you the full text of that law. We're not going to read it entirely. I know it's like a lot of text on the screen right now, but I wanted you to kind of get a sense of the sweep of Section 2 of the Voting Rights Act. I've highlighted certain words in Section 2 that tell you kind of like how broadly this provision really sweeps. So it applies to no voting qualification or prerequisite or voting standard, practice, or procedure. Basically, any voting rule could be subject to Section 2's prohibition. Any voting rule that results in denial or abridgment just means curtailment, narrowing of a right, on account of race or color. It asks courts to look at what's called a totality of the circumstances. It tells you to look at everything involved when it comes to the voting law, the circumstances around it, to ensure that voting is equally open and so that no racial minority has less of an opportunity than other members of the electorate to participate in the political process and elect representatives of their choice. Now, what does that all mean? Section 2 of the Voting Rights Act basically guarantees equal opportunity across races. That's the guarantee of Section 2. And Brnovich, this case that we're going to talk about in detail, is all about what that means, what equal opportunity means as it relates to what are called generally applicable time, place, and manner voting rules. And this was really important because it's the first time the Supreme Court had ever addressed a generally applicable time, place, manner voting rule. What I mean by a generally applicable time, place, manner rule is a voting rule that applies generally across all people, not necessarily on one group or another. The Supreme Court had looked at Voting Rights Act Section 2 claims in the context of redistricting in certain districts over another, but this was the first time it was looking at a law in its entirety and how it impacted voters of color. So it was very, very important in that regard. So how did Brnovich get to the Supreme Court? So this kind of shows you the path that Brnovich took. So it was filed, the case was filed in, like I said, in Arizona, in district court, which is the trial court level, the lower federal court. And at that level, both of these provisions, the out-of-precinct ballot restrictions, as well as the third-party ballot collection ban, were upheld at the district. They had a trial, they looked at the evidence, and they were upheld. Then it went to what's called a Ninth Circuit panel. And the Ninth Circuit covers a number of states on the West Coast, including Arizona. And 3 judges who served on the Ninth Circuit looked at this, and they voted to uphold the provisions at that level as well. Then the Democratic National Committee appealed again to the full Ninth Circuit, what's called en banc review. That means every judge in the Ninth Circuit looked at this case, and they voted on it. And at that point, they voted to strike down the provisions in Arizona law. So they said no luck on out-of-precinct voting restrictions, no luck on third-party ballot collection. And then it was appealed again, this time by the state of Arizona, up to the Supreme Court. So that's how this case got to the Supreme Court for the United States. So the majority opinion in the Supreme Court was written by Justice Alito, whose face you can partially see right there, but he's there, I promise. The majority held that both Arizona laws in question were lawful, and they did not violate the Voting Rights Act. A big issue in this case, what a lot of Supreme Court prognosticators and predictors were looking at and thinking about, was whether or not a test would be adopted by the Supreme Court that would somehow narrow or maybe even expand Section 2 of the Voting Rights Act. But the court didn't do that. The crucial point in the majority opinion was that when it came to the Voting Rights Act, the equally open language from the Voting Rights Act, the text that I showed you before, that was the touchstone of the analysis, according to the majority. Justice Alito said that a totality of circumstances inquiry opens the door to anything that has bearing on that equally open analysis. In order to evaluate whether or not a voting rule runs afoul of Section 2, Justice Alito proposed a series of what he called guideposts, and he said that these would be relevant in determining the totality of circumstances around a voting rule. So I mentioned before that these voting rules, you have to look at them as a whole, according to Section 2 of the Voting Rights Act. And in that totality of circumstances review, he said that these 5 factors were important to consider. Now, dissent takes a lot of issue with this because these 5 factors just kind of came out of a hat. But Justice Alito says that these are factors that are relevant to determining whether a voting rule runs afoul of Section 2. So they include the size of the burden on voters, a comparison to 1982, which is when the Voting Rights Act was adopted. So looking at the voting rule and seeing how it compares to other voting rules that were in place in 1982. The size of the racial disparity that the voting rule creates, the state's general system of voting, what other channels of voting you could have, and the strength of the state's interests. So based on these new guideposts that Justice Alito proposes, the majority found that both out-of-precinct ballots and the third-party ballot collection rule did not violate Section 2 of the Voting Rights Act. Starting with the out-of-precinct ballots, Justice Alito said that having to go to the right polling place, that falls within a category of what's called a usual burden of voting. In his words, these were not any different from driving to a polling place. These are part and parcel of the burdens you run into when you're voting. There were other alternatives to voting in person on election days. You could vote by mail, he said, so that took care of this issue. He also said that the racial disparity was small in terms of absolute terms. This only affected about 1% of voters. So he said because it was so small, it wasn't a problem. And then finally, about the out-of-precinct ballots, he said that the state's interests here in administering elections were good enough to justify this restriction. So it didn't run afoul of Section 2. Now, moving on to the ballot collection rule. Again, Justice Alito said that this was a usual burden of voting. You have to drop off your own ballot or have a family member. This didn't go beyond what other burdens of voting look like. There was no concrete evidence of a disparate impact among other races. And finally, he said that the state's interest in preventing voter fraud, so the chance that someone else might take your ballot and vote for you, justified this restriction. I want to talk a little bit about the dissent, which was written by Justice Kagan, who is also hiding behind the screen right there. Justice Kagan really takes issue with the majority's characterization of the Voting Rights Act. A good chunk of her opinion, about 10 or 15 pages, is devoted to kind of the history of the Voting Rights Act. And she goes through how, in her words, kind of the Voting Rights Act represents the best of America, and it also reminds us the worst of America, right? Racial discrimination. And she talks about how over the course of the last couple of decades, we've seen the Voting Rights Act be dismantled by the Supreme Court. Specifically, she notes that about 8 years ago now, how the Supreme Court kind of gutted one of the other provisions of the Voting Rights Act, which was Section 5 of the Voting Rights Act. Section 5 of the Voting Rights Act dealt with voting rules in certain jurisdictions in the country that were subject to federal oversight. So anytime a certain jurisdiction in the country passed a voting rule, say, for example, Georgia, which had a history of voter suppression, the federal government had to check and make sure that this new voting rule wouldn't have an impact on voters, especially minority voters. That is no longer in place because of a decision by the Supreme Court in 2013. So she said, in light of all this, and the fact that voter suppression is still very much a real thing, you have to consider what the Voting Rights Act was meant to correct. And she notes that Section 2 in particular has a very, very, very broad sweep. If you look at the text of Section 2 of the Voting Rights Act, it says that any voting qualification, any prerequisite to voting, any standard practice or procedure that results in denial or abridgment of the right to vote on account of race is subject to scrutiny. And so that kind of sweeping language, according to Justice Kagan, meant that Section 2 was meant to be a tough tool on states. It was meant to make sure that racial discrimination was stopped. So she also talks a little bit about the totality of circumstances language in Section 2. She says that the totality of circumstances language is used to assess what really constitutes equal opportunity. Remember, Section 2 is all about providing equal opportunity to all races. And equal opportunity, in her words, are a function of law and background conditions. So it means it's partially a legal analysis, but also partially a factual analysis, what's happening on the ground. And it allows for states' interests to be accounted for, right? So the state can have interests that might burden voters, but the state isn't allowed to say that anything is their interest, right? They have to offer some sort of justification. She also critiques the guideposts that Justice Alito talks about in the majority opinion. On the size of the burden, she says that Section 2 doesn't say anything about how big the burden has to be. It just says that, that any, voting rule that abridges or denies the right to vote on account of race is unlawful. The other channels of voting argument that he makes in terms of the guideposts, she says that Section 2 doesn't care about that. It just cares about whether methods of voting individually taken are equally open. The 1982 factor that I mentioned, she says that Section 2 intended a localized appraisal. It didn't set in amber kind of what was true in 1982, so that guidepost doesn't make sense according to the dissent. And then for the state interest argument, she says that the state has to have a good reason, and it has to have the least discriminatory way of advancing its interests. So applying all of this reasoning, the dissent looks at the out-of-precinct rule and says that the burden that's imposed is not actually unremarkable, as the majority says. It actually turns out to be a huge number of ballots. In fact, if you look at Arizona, she points to the 2012 election, where out of 35,000 ballots that were thrown out across the country because of these kinds of out-of-precinct rules, a third of them, so about 10,000 of them, were thrown out in Arizona. So she says it's a huge number. And she says that even if it was a small number, in states, elections often are fought at the margins, right? So even small numbers make a difference, especially in states like Arizona, which, as we know, is still litigating the 2020 election right now because the results were so close. And then finally, the point she makes about the out-of-precinct rule is that minority ballots were far more likely to be discarded than the ballots of white voters. And so the disparate impact says that this rule should be stricken down. So then she talks about the third-party ballot collection rule, and there was one main point that she made about this. She said that the majority failed to evaluate the totality of circumstances, aka the facts on the ground in this case. So like I mentioned before, a lot of the voters who are impacted by this third-party ballot collection rule are Native American voters. And she says without looking at that fact on the ground in detail and really thinking about it, the majorities failed to conduct a proper analysis under Section 2. So what does this all mean? What does Brnovich mean? Why is it so important? Well, it's bigger than just the two Arizona laws at issue. It's like I said before, this was the first time the Supreme Court was considering Section 2 as it applied to these generally applicable voting rules. So this was really a case about what Section 2 of the Voting Rights Act means, right? Although these Arizona laws were important, this is about a much bigger, situation about how the court interprets Section 2. Now, a lot of people coming into this case, when the court granted cert on this case, were worried that Section 2 of the Voting Rights Act would be gutted in the same way that Section 5 would be gutted. And it wasn't. Section 2 very much, remains the law of the land. I am litigating cases under Section 2. They're still alive. We're still in court right now over them in Georgia. So Section 2 remains, but the sweep of Section 2 might have been diminished somewhat, right? There are a lot of unanswered questions about what these guideposts will mean going into the future. What kind of burden will be enough for courts to consider? What does this 1982 comparison mean? And so there's a lot of questions that we'll see that will need to be resolved by federal courts about that. And then finally, kind of one of the big picture issues from this case is that the Supreme Court kind of gave a stamp of approval for the state to assert an interest in claiming to prevent voter fraud. And that's a big deal because a lot of bills being passed in state legislatures right now are using voter fraud as a reason to justify very draconian voter laws. So that's going to have a huge impact on litigation as well. So we will see what happens with the Voting Rights Act as we move into kind of this new era. But I'm sure this will not be the last case that's litigated on this, and we'll have to see what the court does in the future. Thanks so much.
Our final speaker this evening, Stephen Bradley, is the Superior Court Judge for the El-Jourbagy Judicial Circuit. And he proudly serves the people of Morgan, Greene, Jasper, Putnam, Baldwin, Jones, Wilkinson, and Hancock counties. Judge Bradley received his undergraduate education cum laude at Emory University, where he was a Hayward Pierce Scholar. While obtaining his law degree at the Cumberland School of Law, Judge Bradley was honored to be the lead oralist for the moot court team and simultaneously presided on the mock trial and moot court boards. Judge Bradley clerked for the late Honorable Edward S. Smith of the Federal Circuit Court. Judge Bradley has been a public servant in the El-Jourbagy Judicial Circuit for over 27 years. He joined the District Attorney's Office in 1994. As an assistant district attorney, he personally handled more than 12,000 felony cases. Judge Bradley became a district attorney of the El-Jourbagy Judicial Circuit in 2015. He oversaw the expansion of victim services, including starting a circuit-wide domestic violence task force and opening the circuit's first child advocacy center, the Bright House. In 2020, Judge Bradley was elected to the Superior Court bench where he serves today. Appropriately, considering his career as a prosecutor and now Superior Court judge, he will discuss Jones versus Mississippi, a case that addresses juvenile sentencing. Judge Bradley.
I'm sorry. Good evening. Thank you. Yeah, there we go. You know, years ago, I told my father that I was going to be a lawyer. And the first thing he said to me, he said, son, that's fine, but it's wrong for somebody to make money arguing, who enjoys arguing as much as you do. And I thought that that was just me. And then I met a bunch of lawyers, and I found out that if you want 4 opinions on any case, you ask 3 lawyers, okay? And that is true everywhere I've ever been. And I thought that was just lawyers that I knew until you started studying the Supreme Court. The Supreme Court is made up of the most fascinating, dynamic people who are trying their best to do justice. And the case we're about to talk about has some of the most dynamic, interesting intricacies and undercurrents I've ever seen. All right, let's start with Shannon, Mississippi. Our story begins in Shannon, Mississippi. I know you say, where is Shannon, Mississippi? Go right ahead, Jehan. There it is. It's in the northeastern corner of Mississippi. And go ahead. At that time, can we move the little screen down? Put it in the lower right. Perfect. Thank you. Brett Jones was 15 years old, and he's living with his granddad. He had had a tough time of it. His granddad comes in, finds him in bed with a young lady, kicks the girl out. Argument ensues. Brett follows granddad into the kitchen. At that time, gets heated. Brett pulls a knife out, stabs his granddad, breaks the first knife off, continues to grab another knife, and stabs him 8 more times, a total of 8 times, kills him. Now, he gets tried in Mississippi. He is convicted. At that time, he is sentenced to life. That's the only option. And the state of Mississippi did not have a parole board. So he's going to do every day of that life sentence. It's conviction. The conviction is appealed to the Mississippi Court of Appeals. They affirm it. Okay, it's relatively straightforward, simple case. Now, these are, on the upper left-hand corner, that's Brett Jones at the time of conviction. In the middle, that's him receiving one of the many diplomas that the dissent is going to go on to talk about, which actually become important to them. And in the lower right-hand corner, that's Brett as he appears, I don't know when, but on the Mississippi Department of Corrections website. Go right ahead, please. Now, all of the cases we're about to talk about ostensibly, in theory, revolve around the Eighth Amendment. You say, well, what's the Eighth Amendment? You guys remember the Bill of Rights. In the Bill of Rights, the Eighth Amendment, when it was passed in 1789 through 1792, depending on the state, at that time, what we were most worried about was what? Excessive fines and bails. That was the first thing that the framers and the Federalists were concerned about. After that, it was cruel and unusual punishment. Remember, in 1789, some places were still using what we now consider to be medieval torture, such as the rack. We're not talking about the rack. The Eighth Amendment, you almost never see litigation about the first clause. It's about the second, the definition of cruel and unusual punishment in the modern age. Go right ahead, please, Professor. All right, go hit the first one if you would. And the Supreme Court for the last 12 years has been absolutely fascinated about how the Eighth Amendment affects juveniles. Now, I say juveniles, they talk about some 13-year-olds, but there's some dicta that really says we're talking about 14 to 18-year-old kids. And the first one we'll talk about is Graham versus Florida. And Graham, a 16-year-old was convicted of armed burglary. He was given probation. He wrote a letter to the judge. The judge took pity on him and gave him 3 years probation, but didn't adjudicate him. It's the same sort of provision that can be obtained here in Georgia. At that time, he gets in more trouble, commits a burglary 6 months later. He gets in trouble, comes back in front of the judge. The judge listens to the story of the first crime and the second crime and lights him up, gives him the maximum he can give him, which is life in prison. Florida doesn't have a parole board. By definition, that is a life without parole sentence. What happened in Graham was they said, you can't give a juvenile a life without parole sentence. And the reason they used, for those of you who are Supreme Court wonks, they went back to the death penalty sort of conversation. They said this is the second most severe type of punishment. So it's like the first most. They relied on Inman and said, unless somebody kills, intends to kill, or attempts to kill, you can't give them a death penalty. The same is true for a juvenile on a life without parole sentence. They didn't say an adult on life without parole, a juvenile on a life without parole sentence. Go right ahead if you would, Professor. Now, Miller versus Alabama comes along a couple years later. Miller is central to everything because Miller actually combines an Arkansas and an Alabama case. And we'll talk about the Alabama side of it. In the Alabama case, these fellas get really smart. They try to rob a fellow who is passed out drunk. He wakes up. They get a baseball bat, beat him with a baseball bat. They don't think he's dead enough, so they burn his house down. It is murder in the course of an arson. At the time he's convicted of that as an adult, they brought the case up to adult court. The state of Alabama had one option for sentencing, and that is life imprisonment, and they did not have a parole board. Therefore, life meant life without parole. Miller said you have to consider and balance proportionally all of the likelihood that a juvenile is going to have changing transient properties they like to talk about, and they're going to grow. They're going to get rehabilitated and balance that with severity of the crime. It should be a rarity. And what Miller ultimately said was, because you have to balance it, it can't be a mandatory sentence. Everybody gets that, right? In other words, a state can't say juveniles must be sentenced to life without parole. Once it becomes an obligation for a sentencing judge, it's not legal anymore. It is not a constitutional option. That's what Miller stands for. The problem was, and comes out later, is that Miller spends an awful lot of time talking about, we expect this to be a rarity. You'll hit it again, please. A couple years later, the Supreme Court comes back to the same topic in Montgomery versus Louisiana. Now, Montgomery, okay, I want you to notice something. Remember, Brett Jones kills his grandfather, Burtis, on August 9th, 2004. Everybody with me? That's 11 years before this decision. Well, guess what happens in Montgomery? They're deciding a case about a fellow who, in 17, killed a deputy sheriff in Louisiana in 1963. At that time, they said it is a substantive right, and therefore we got to go back through every conviction that was ever obtained that violated Miller. Justice Thomas, if you will strike it again, please. Justice Thomas said during Montgomery, he said, what? You guys can't do this. Nothing in the Constitution gives you a retroactive right. The truth is, if you want any predictability in a court system and reliability, you have to be able to say to folks, if you're following the law today, it's not going to change. If you interpret Montgomery the way you all are trying to do it, according to Justice Thomas, all you're doing is letting folks walk on pins and needles because they never know what's coming. This case, he's convicted in 1963. 50 years later, you change the rules in Miller. They say, just doesn't make any sense. He lost. Okay. Now, Jones versus Mississippi brings up a lot of really neat ideas. The Montgomery case is decided on what's called substantive versus procedural bounds. Now, substantive means the bulk and the reason of why we do it. Procedural means how we do it, right? And these are competing interests because sometimes how you do things ends up affecting what happens. Federalism is whether or not the state gets to decide or the Constitution gets to decide. And there is nothing more state-bound than sentencing in a criminal case. I promise you, unless you're in the federal system, you're going to get at least somewhat different treatment in Idaho versus North Carolina because states get to decide criminal punishments. And the third thing is stare decisis, and that is standing by a decision that's already been made. I promise you that is also a point of great contention because the question is, how much respect do you give to a case that happened years ago? Go right ahead if you would. Now, Jones' initial appeal, go ahead and hit it again if you would, thank you. Remember, after Miller, because remember, he's convicted years before Miller. After Miller, the Mississippi Supreme Court gives Brett Jones a chance to come back because it was a mandatory murder life sentence. And they look at it again, they say he gets another sentencing hearing. There's a new sentencing judge hears all the facts, listens to everything, says he is balancing, says he's considering the youth and the transiency of youth, and sentences him to life without parole again. Now, the issue becomes whether the Eighth Amendment requires that sentencing judge, that second sentencing judge who said he was balancing things, to say how he came to a life without parole sentence. Is he supposed to give some specific facts? Is he supposed to say, I believe this juvenile is incorrigible for the rest of his life? Does he have to find, as Miller said, permanent incorrigibility? He would. Enter the Supreme Court in 2021. This was decided April of this year. This is new law. Go ahead. They are scrapping. These justices can't really decide anything that they agree on. There's very little similarity, if you would, please. Now, I love SCOTUS blog. For those of you who haven't found it, that our Supreme Court wonks, it's wonderful. They keep statistics. You'll notice, hit the next one if you would. Last term, there were 69 written opinions, as Professor El-Jourbagy told you. Of those, 4 out of 5 got flipped. 80% were reversed. This is the world in which the Jones case comes in, all right? You'll strike it again. Now, you'll notice these are slightly different, so I don't know the numbers you got, Jehan, but this comes off SCOTUS blog. Hit it again if you would. Sotomayor writes the dissent. Justice Kavanaugh writes the majority, and they agree 66% of the time in the last year. I've been married for 27 years. We don't agree 2/3 of the time. I'm stunned at that. Hit it again if you would. Through all the opinions I've told you about, we have constructed a Eighth Amendment that is like a Jenga game. Each fact is slightly different. This bunch of justices is pulling the next Jenga, if you would. Now, the majority says, look it, I know what we said in Miller, but nothing in Miller said that a judge had to use specific words. There are no magic words out there. We're not making a test. If states want to make a new test for them, they can. For instance, in death penalty cases, they talk about some states make jury have specific findings. We never said that. If you guys want to do that, states can do that. We're not going to dictate that to you. They also said nobody has ever required such a leap into, I have to find A, B, and C in order to make a specific kind of sentence. That's never been a sentencing practice. That's never been in the Constitution. That's what they said. Go ahead. Justice Thomas said, I told you you were wrong in Montgomery. If you had listened to me, we wouldn't have this problem because both the majority and the dissent have to contort themselves. They're twisting everywhere to get around Montgomery, because Montgomery is the fly in the ointment for them. One wants to make the procedure dictate, and one wants to make the substance dictate, if you would. The dissent, written by Justice Sotomayor, said they want to savage the majority. And in fact, there's something been made. She starts off by saying, I dissent rather than I respectfully dissent. This is how they throw down, I guess, at the Supreme Court. But the truth is, she doesn't really. She basically says, I just don't believe that judge really balanced these things. What they're saying is, as Justice Thomas pointed out, you guys both want a different result. And what Justice Sotomayor says is, if you really balance this kid's bad history and you look at his chance of rehabilitation, look at the diplomas that he got, look at what he's done while in prison, you can't say he's permanently incorrigible. We want a finding of fact from that judge in Mississippi because we just don't believe. We wouldn't have come to the same result. And what Justice Thomas said was, you guys don't get to pick the facts, you have to follow the existing law. Well, what's interesting is that the dissent ends by saying the majority has so little respect for stare decisis that they have had to come up with this ruling. It is a fascinating opinion. Now, where does that leave us as to juveniles with life without parole? You can go ahead, all of them. Juvenile offenders, probably those 14 years and older, can be sentenced to life imprisonment without the possibility of parole. It must be for a homicide offense. It cannot be mandatory, and the judge sentencing must balance the factors of rehabilitation and youth against everything else that appears from the crime. All right, I think that's it. Thank you.
Thank you so much to all of our panelists. Before we leave, it's not often that you have 4 people like this at your disposal to ask questions that you might have. I'm going to turn it over to Steve Elliott Gower, who's in Arts and Sciences, to facilitate the question and answer.
And Jehan, how long do we have? 20 minutes?
15.
15, 20 minutes. Okay. I think what I'm going to do is go up to the cheap seats first and see if you guys have any questions up here, and then I'll move back down. Any questions up here in the peanut gallery? Any questions down here in the exhibit?
I got a raised hand back there.
Has working on a case ever changed your initial belief or opinion on that matter to a case?
So the question is, has working on a case ever changed your view?
Your stance on it, like how, like maybe what you thought before and then working on it.
Has anyone ever gone into a case and felt like you shifted your view or your stance? Now everybody was hardwired to start and hardwired at the end.
I will say, yes, that's happened to me a number of times. Sometimes I end up with a very different view of the facts, of the law, of the analysis. But often what I got was a more nuanced idea that when applied, the law has to balance so many different concerns and factors that we may not want to at first blush consider.
I'd like to ask a quick question of Mr. Kessler. How many times have you argued before the Supreme Court? How many times have you argued a case before the Supreme Court? And what is it like?
So for me, it was my first Supreme Court argument. And I'd been there at the council table several times, but I've never been the one arguing. It is a awe-inspiring experience. I think all of us would agree with that. There's a certain majesty of the institution and arguing before the justices. It also caused me to do more preparation probably than any of the appellate arguments I've ever done. I've done 50 appellate arguments, been up before the Supreme Court. So I found it to be uh, something that gives you respect for the institution, respect for how well prepared the justices were, every single one of them. There were 17 amicus briefs filed in our case, and it felt like the justices read all of them as well, or at least had their clerks read all of them and summarize them to the point where they were referring them. So it was quite a meaningful experience to be able to argue to the court. And of course, when you win 9-0, you feel pretty good about the experience at the end.
Thank you for sharing that.
For Judge Bradley, in the case Jones versus Mississippi, how strongly do you think Jones' background should have been considered, given the severity of the crime? Did looking to the case change your perspective on him at all for the crime?
I think that for the dissent, it was critical. They wanted the world to be fact-driven, and they wanted the decision, as I mentioned, to be somewhat different. I think for the majority, no, that's not true. And honestly, Raul, you may disagree with this, but I think that this court right now doesn't want to make specific tests. They don't want to make specific hurdles. Lawyers like to call them safe harbors. They say, look, as long as it meets some basic standard, we're going to pass it along. And you can argue that that's a deference to states or not. I don't know that the facts surrounding Mr. Jones carried the day. I think that the procedure carried the day on that one.
Other questions down in the front? What? Oh.
Mr. Kessler, did you hear that? There was a question.
I could not hear that.
Okay.
My bad, Mr. Kessler. So for the NCAA case, what did the timeline look like from the beginning of the case to the Supreme Court ruling?
So the case took 6 years to get up to the Supreme Court. We had several years of intense discovery, which is typical for big antitrust cases, and especially under what's called this rule of reason analysis. We had, probably expert in fact depositions, probably 75 to 80 depositions that were taken in total in the record. And then we had to do a 10-day trial. And then we had to go through the appeal to the Ninth Circuit. And the argument in the Ninth Circuit was the last argument the Ninth Circuit did before they shut down for COVID. I remember we were already just knocking elbows with the other side by the time that argument was done as a live argument. And then after the Ninth Circuit decided, you then have the process of getting appealing for cert, which takes some time as well, and then the Supreme Court granting it and scheduling that argument. So yeah, it's a long haul. Antitrust cases are big, long, difficult, expensive endeavors. But in the end of the day, they can make an important difference.
Thank you.
Any other questions, either down in the front or in the back? Yeah.
This is more so for Stephen Bradley. Did you consider your own personal ethics when following the Brett versus Jones case? And then also in general, is it difficult to separate your judgment and emotions from the law and reason in your cases you deal with?
Well, I've never been asked to implement Brett versus Jones. I mean, I've certainly not had a juvenile in front of me for sentencing. But I don't think you should necessarily remove your personal feelings. You certainly shouldn't remove your ethics or morals from a decision. That means that you have to compare that and work that around existing law. Sometimes there are laws that dictate what have to be done, but most things are discretionary. Most things give the court some latitude. The question is, what's the best outcome? As one smart judge used to say, who Professor El-Jourbagy knows as well, he'd say, you rarely get the choice between a good result and a bad result because those are easy calls. It's between two terrible outcomes or two great outcomes, and those are hard. Does that answer the question?
I had a question for Mr. Garabadu. How do you determine voting laws if in order to stop voter fraud or fraudulent voting, it may affect a certain culture? And can you find a balance in that?
That's a really good question. And it's very difficult to determine when a legislature says we are looking out for voter fraud, whether, to disentangle motives. So part of the reason why Section 2 is so revolutionary is that it asks you not to just look at the motives of a law, it asks you to look at what the effects are in what's called a results test. So even if a legislature isn't trying to racially discriminate, if the effects of a law end up having a disparate effect on one race over another, that gives courts enough of a tool to say this law can't go into effect. And so that kind of tells you how, and this was, the Voting Rights Act, people forget, the Voting Rights Act of 1965 was a big, big deal. It was, one of the most hard-fought pieces of legislation. Blood was shed over getting this legislation passed. But even the provisions of the Voting Rights Act, they're quite robust, even in its current form today. So what the court in Brenovich said about voter fraud particularly was that if the state can reasonably assert that it has an interest in voter fraud, that's enough for them to enact a law that might have, certain consequences. Now, the court didn't necessarily say that, if it had a disparate impact, it could still go into effect. But what the dissent said was that if a challenger to a law could show that there was a less discriminatory way to prevent voter fraud, then that law had to be stricken down. So, does that answer your question?
Other questions?
Take one more question at this point.
Yeah.
Do you raise your hand, Ms. Copeland? Okay. Terrible when I know your name. Well, thank you so much to the panelists. Let's please give them one more round of applause. Should you have any questions of the panelists, feel free to approach them. Thank you and have a good evening.
Well done.
See everyone.
Bye.
Very
Thank you so much for
educated.
being here,
Thank
Mr.
you.
Kessler.
Nicely done.
Thank you.
Thank you very much.
Yeah, that was interesting stuff. I enjoyed doing this.